Hello, I'm attorney Brad Micklin. I'm the managing member of the Micklin Law Group, which is a law firm located in Nutley, New Jersey, and concentrating in divorce, custody, and family law issues. Making this as a series of videos I put together that I send to my consultation clients before I meet with them, outlining the top 10 questions that I tend to be asked by most people. My hope is that answering these questions in advance will get them out of the way so we can really sit down and maximize our time together and speak about the real important issues of your case. So I hope these questions help you, whether you're preparing to meet with either me or an attorney anytime soon. So these are the top 10 child custody related questions I get during a consultation. First one is, how much is this going to cost me? And unfortunately, it's very difficult to ascertain what a case will cost, any case. The terms and the fee schedule will vary depending on the law firm that you're with. Our firm, for instance, has certain sliding scales to our hourly rates and some flat fee offers that we make depending on the complexity of the case, but not necessarily all firms do that. So it's going to be difficult. If you're doing it in an hourly case, it's going to turn on the complexity of your issues, the relationship of the two parents, meaning how well they get along, how reasonable they are with one another, and the court's ability to schedule the case promptly and to manage it promptly, meaning that you don't spend all day in court, they get to you early. Those are going to greatly influence how much your costs are for an hourly arranged case. Second question is, how long will a custody case last? And I estimate anywhere from 3 to 9 months. I know it's sort of a large window, but it depends on how quickly the court's going to schedule it and whether or not the hearings that I'll talk about in a second, whether they're scheduled at the same time or on different days. So next one along those lines is, how many times will I be required to appear in court? I tell clients to estimate anywhere from 3 to 6. The first appearance is going to be the return of the application. The second appearance is going to be court-ordered mediation, which almost always follows a custody case. Now, sometimes the mediation is offered at the first hearing, so that's why the number of hearings you have may vary. And then the last one is going to be, or at least the third one would be, where the court makes the actual decision on the custody application. The reason why there's 3 others that may be in there is that there may be hearings to determine whether or not there's going to be experts appointed. There may be case management if the court needs to sort of schedule the case and see where it's going. So that's where you get between 3 and 6. Second one is, the fourth one is whether or not the court will interview my child. As general practice, courts don't interview children. Many believe that they don't necessarily have the background to ascertain the sort of mental or psychological issues that may be necessary in determining a custody case. They leave that to experts. But in the cases where they're going to, one, it has to be usually that one of the parties have requested it before filing, and the judge will usually do it in what's called in camera, which means behind closed doors and without the parties or the parents watching it. It's usually going to be either video or audio recorded or both. You will be able to access it later with a certain court order, but you won't be sitting in during the interview. The number 5 question, the top 5th question I get is, at what age can my child decide whom he or she wants to live with? And my basic answer to that is there is no age, as long as they're unemancipated, which is generally 19 or below. Court will not let a child make a determination of custody. One, they don't know that a child at any age has the ability to make such a sophisticated decision. And 2, probably more importantly, they don't want to put any child in between their fighting parents on this kind of an issue. Now, that being said, at around 13 or so, they will start to consider what a child's desire is for custody. They'll listen to it, but they will not let that child ever decide. Next is, what does a parent need to prove in order to change custody? And the standard is the best interest of the child. You have to prove a material and substantial change of circumstances that inures to the best interest of the child, which means 2 things really. One, something significantly has changed, but more importantly, the second part is that changing custody is in the best interest of the child. And the reason I emphasize that is a lot of parents will change or seek to change custody because employment changes or because living arrangements change. But these are really issues more commonly that benefit the parents and not the actual child. You need to show that the benefit or the change is to the benefit of the child, not that it's just better for him or her, but it's in the child's best interest. Next is, will I be able to have the other parent pay my legal fees? Now, there is law that suggests in some circumstances a family court judge can make one parent pay the other parent legal fees in a family matter. They will usually look to issues like discrepancy in income and good and bad faith positions that were taken during the litigation. However, I tell my clients, don't expect it. One, it doesn't happen that often. And two, if you don't expect it when you're paying your legal fees and you receive it in the end, you're ahead of the game. If you go through the litigation with the hopes of getting fees paid back to you and you don't, you're going to suffer a very large detriment at the end. Number 8 is how many times can the other parent take me back to court? That's really not limited, unfortunately. The courts have very little discretion in closing somebody's access to the courts, whether it's for custody or any other reason. However, if it does look like they're abusing the process, there can be other sanctions that are imposed, like the payment of legal fees, make up parenting time, changes in custody. Sometimes it's even threatened when somebody's abusing the process like that. But a bright line rule doesn't exist because it's a very harsh remedy to impose. Number 9 is, can I refuse parenting time to the other parent? That generally means parental interference. So the question will depend on whether or not you have a court order. If there's a court order for parenting time, you cannot refuse parenting time, even if you think your child's at risk of harm. There are steps to take and agencies to help you if you think there's a risk of harm, but you don't have the discretion to disobey a court order. If there's not a court order and you think it's in your child's best interest, you do have the right to refuse parenting time, but I would do so cautiously. And last is, and probably the most common on all of my child-related issues, the last is, can I leave the state of New Jersey without my other parent's permission, or can the other parent leave without my permission? The answer is a very tricky one, so it's important that you understand the distinction. If you've ever been to court with the other parent on issues about the child, whether it be child support, parenting time and visitation, custody, anything, even possibly domestic violence cases, then you cannot leave the state of New Jersey without either the other parent's consent or a court order. That statute says if custody has ever been an issue, you cannot leave. So the examples I just gave you are where the courts consider custody to be an issue, even if it wasn't an actual custody case, even if you were just in court for some issue about your child. Now, if you've never been to court on any issue regarding your child, then you can leave the state of New Jersey without parents' permission. I hope these questions and this information helps you prepare for whatever meeting you may have coming up. If you need more information, you can go to our website at micklinlawgroup.com, which is MICKLIN, lawgroup.com. We have downloads on the first page, ebooks. We have a video consultation room that has short questions and answers that I address. And then there's a webinar archive page where I have monthly webinars I upload that dive much more deeply into these types of issues. All the information is free. You don't have to give us an email address. You don't have to fill out any kind of form. All you do is click on the media that you want to download and it's yours right there. So I encourage you to watch as many as you think will be helpful. Feel free to send them to anybody that may benefit from them. If you still need more information or more help, you can also reach us at 973-562-0100. Thank you.